Why don't you want her to remarry when you are no more? You see, some men want to imprison their wives after they are dead by ensuring that their wives do not remarry as a condition for getting the properties given to them in their will. But why? Wait a minute. I thought the oath was till death do us part. But it appears that this oath does not apply to some people even after death. Some men will instruct their lawyers to insert a clause like this in their will. I hereby give my 4-bedroom bungalow house at number 1 Lord Dynasty Street, our matrimonial home, to my beautiful and faithful wife, Veron Jones, absolutely, to enjoy all benefits therefrom and exercise all rights of ownership. But if she remarries at any time after the distribution of my estate, this gift becomes revoked and shall revert to my residuary estate. The above gift clause in a will is a faulty one and will be effective in part only, but not in whole. To understand this very well, let us break the clause into 2 parts. Part 1. I hereby give my 4-bedroom bungalow house at number 1 Lord Dynasty Street, our matrimonial home, to my beautiful and faithful wife, Veron Jones, absolutely, to enjoy all benefits therefrom and exercise all rights of ownership. The part 2 says, but if she remarries at any time after the distribution of my estate, this gift becomes revoked and shall revert to my residuary estate. The wording of part 1 of the gift clause is realistic and legally enforceable in favor of the wife, because it clearly expresses the wishes and instruction of the husband to give the house to the wife in his will. As a gift, it is complete and becomes the property of the wife once the executors transfer the property to her. Now, the interesting part is that she can immediately, upon receiving the gift, do whatever she pleases with the property. She can even sell it because she is now the absolute owner of the property. The wording of the B part of the clause, which revokes the gift if the wife remarries, is quite faulty, useless, and unenforceable against the wife. So far as the property has been gifted to the wife, she can immediately exercise all the rights attaching to the property, including the right of sale. Take note that the condition given by the husband in his will is not a condition precedent, which means it is not a condition that she must fulfill before she takes the property, but a condition or something she must not do after she has already become the owner of the property. Now, the big question is, what would happen if the wife sold the property to another person and remarries 10 years after selling the property? What will happen to the deceased husband's instruction that revokes the gift if she remarries? Will the executors go and recover the property after 10 years from the person that bought the property from her? Simply put, some things really do not make sense. Don't be caught in that web. Please be careful the kind of instructions you put in your will or trust, because not all that you have put down will be enforceable when tested by law. As for men, make a gift to your wife if she wants and deserves it, and look away. If she remarries, it's her choice, and you should not make that decision for her. You cannot force her to honor you by not remarrying. She will be the one to decide if she wants to honor your legacy and memories by not remarrying. Always remember that an unplanned estate is a potential chaos being nurtured by you today. I am the estate planning attorney.